get the mic. Yes. We'll resume by the court seeking clarification on certain issues that have risen in the course of the submissions that have already been made. And I'll begin by asking Justice Ouko.
Thank you, Judge President. I have a couple of clarifications. The first one is the elephant on basic structure. And I need clarifications from the Solicitor General, George Oraro Senior Counsel, George Gilbert, and those, Mr. Mbulua, and those who said that basic structure is in the Constitution, but is not applicable. Just to clarify, what does that mean? It sounds like a contradiction. The next clarification I seek, perhaps from Mr. Karori, and those who represented the President regarding his role in popular initiative. If he's entitled to do so, why did he pass the baton to the promoters to finish the race? He would have gone all the way to the finishing line. Number 3, for, I think, the counsel who represented the Speaker of the Senate and the Senate, and I think Counsel Morara on the referendum question. My reading of the opinion of the Court of Appeal, Lady Justice Nambuye, Lady Justice Okwengu, and Mr. Justice Kiagi appears to me to have been unanimous that you must have separate and distinct referendum question or questions. Mr. Justice Gatembo seems to me also to have agreed with that position, save that he qualified it by saying, depending on the nature of the proposed amendment. Lady Justice Ichale did not express her opinion on this question. Mr. Justice Tuyot said the issue was not ripe. So therefore, if you look at the opinions of the judges, it would appear that the majority agreed with the High Court that you need distinct question or questions. And therefore, in my view, and I'm asking a question, if you look at the disposition, the final disposition on this matter, the court said they set aside the declaration by the High Court regarding the referendum question. So who are the majority? The majority, in my view, upheld the High Court. So if counsel involved in this can confirm that I'm right or wrong, then I'll be satisfied. The final one, really, I don't know whether there's a question. IEBC didn't seem to have addressed us, or I can't see in their submissions, the issue of delimitation of boundaries of the 70 constituencies. And yet I thought this really is directly on their role. So I don't know whether it was tact or it was strategic, but perhaps the counsel for IBC can tell us whether they have really no view at all regarding the second schedule. I thank you, Judge President.
Thank you. Judge Renao.
Thank you very much, and thank you, counsel, for your submissions. Judge Oko has picked on 2 of the issues I want a clarification on, but I have 3 others. The first is to the eloquent Dr. Eboso. Dr. Eboso, you made a very interesting submission that sovereignty is extra-constitutional, that it is not reposited in the Constitution, and that for that reason the basic structure is implied and not express. And my question is, where then do we get this sovereignty reposited at? Is it fluid? Is it misty? Where do we grab it? Where do we locate it? I'm asking this question because you also made reference to the Kesavananda case. In that case, at paragraph 368, the court said, therefore, if any part of the Constitution was intended to be excluded from the operation of the power to amend, it would normally have found a place in or below Article 368, which is the amendment provision in the Indian Constitution. The court also said, then again, we find that when the people, through the Constituent Assembly, granted the power to amend, they made no reservation in favor of the people. The people completely withdrew from the process of amendment. So that if it is true, as you said, and Aluocher also said the same, that the people are sovereign, yet you are saying that sovereignty is extra-constitutional, what are you telling us? I need to understand that. The second question is to Mr. Kirago Kimani on the powers of the president to initiate a popular initiative. The question is there precedent elsewhere in your research where a president has initiated a popular initiative in a constitution similar to ours? And following Judge Oko's question, therefore, how far should he have gone? And if not, what is the issue there? And tied to that, there was controversy right through from the High Court whether the President of Kenya in fact initiated this popular initiative. Are you admitting that he did? Or what is your position regarding the particular event? Did President Uhuru Kenyatta initiate this popular initiative, or another entity post his own actions initiated the popular initiative? And to Isaac Aluocher, again, thank you for your submissions. One of the issues that came through the Court of Appeal decisions was the finding by one judge that, in fact, the question whether we should have multiple or a singular question in the amendment bill was premature, because the IEBC, which is the body that is mandated to do certain things, had not reached the level at which it crafted any referendum bill. Are you then submitting that, in fact, Justice Tuyot, I believe, was correct in saying that the issue was premature? Or are you, Isaac Aluocher, saying we as this court should proceed and make a determination on the question whether, upon reaching the level of the referendum, the amendment bill, in your view, should have one question or not? So my question is the prematurity or not of the amendment bill. I thank you, CJ.
Thank you, CJ. Thank you for all counsel who have submitted thus far. I have a question to Mr. Aluocher. You've been very clear that it is the preserve of Parliament to legislate. And indeed, it is your position that the judges, therefore, in the High Court ought not to have read into the Constitution anything that is not in the Constitution. Yet, on the other hand, you've suggested to us that the bill that goes to the referendum ought to be in the format of separate bills, each having a different question. Looking at the Constitution on bills, Articles 109 to 114, from 255 to 257, there is no such detail there is no such prescription of how the bill ought to look like. So I'm just asking, are you asking us as a court who ought not to legislate to put in that prescription, or are you asking us perhaps, are you suggesting to us that it is Parliament that ought to put that prescription into, on the issue of the bills? That's the first one. Secondly, you're very clear that the Constitution does not allow the President to use state machinery under Article 2.2. If you look at the presidential functions, could it be possible, is there a possibility that the President, in exercising the functions given to him by the Constitution, can indeed move amendments to the Constitution in order to achieve the functions given to him under the bill, like the unity, to unify the country, or any of the different aspects of his functions? In that situation, what would your position be? My other question then would go to Dr. Eboso. You talked a lot about the promoters of the amendments and how it should be an ordinary Kenyan who can go and look for the million signatures and start the process. Would, in your opinion, these promoters be restricted in eliciting support from politicians, from the President, from any other Kenyan? How, in practical terms, would you see the promoters moving to meet the requirements, to collect the signatures and to process all the issues required up to referendum? And also to you, Dr. Eboso, what do you think of a proposition that the President himself can initiate legislation? And does he do this? How does government policy become legislation? Does the President initiate legislation? And if he does so, is it a possibility that then he could initiate the legislation that is the bill that would then accumulate in the referendum? Finally, this is not restricted to any party. I would just like to hear from any party that thinks that they may be able to answer this, about the 4 sequential steps. Are they expressly provided for in the Constitution? Are they implied, and where? That's all. Thank you.
Thank you. Justice Wanjara.
Let me also join my colleagues in thanking Council for your very elaborate submissions on the questions before us. This is directed to Mr. Karori and to a certain extent Mr. Oraro and also Gilbert. If I understood your argument correctly, you did submit to the effect that a popular initiative kicks in, a popular initiative process kicks in after the collection of signatures, if I understood you correctly. Now, if that be the case, if that be your submission, what is the basis of this argument? Because then you would have to tell us what is a popular initiative, what makes an initiative popular within the context of this provision, I think Article 257. So why would you say that the process then kicks in only after the collection of signatures? And then the next question, it touches again partly on what my brother Judge Oko asked regarding the basic structure, and this has detained the courts right from the High Court now up to the Supreme Court. Again, if I understood your submission correctly, again, this again goes to the three council. You are saying that when you look at our constitution, you can see a basic structure. In Article 255, that therein is a basic structure. What is inspiring that characterization? Why is it a basic structure? Why are you saying that the specific provisions to which you have referred, actually constitute the basic structure? Then, by the same token, you argue fairly strongly that although that be the case, the basic structure doctrine, I think as understood from the Kesavananda case, is not applicable in Kenya. Why is it not applicable? What predates what? What inspires? Is it the doctrine from which your basic structure, as you have identified it, derives? Or is it vice versa? Or is the basic structure, as you identified in our constitution, something that falls beyond the doctrinal aspects of what we are dealing with here, and therefore that doctrine is not applicable? So those are the two questions. Because there could be a contradiction, but if you clarify, there may very well not be a contradiction. Why do we locate a basic structure in our constitution? And why do we, in the same vein, submit that the doctrine of the basic structure doctrine, however you call it, is not applicable in our constitutional setup? And Mr. Aluochiri, you may wish also to chip in, because your argument was not on all fours with the three council, but you did also say that the basic structure doctrine, as you understand it, is not applicable in our constitutional architecture. Thank you, CJ.
I would also like to seek a small clarification, just a little trajectory on this issue of the popular initiative. I think Justice Wanjara has asked when the process began. The clarification I seek is that there were processes that led to the setting up of the BBI task force and the steering committee, as well as the fact that members and staff therein drew remuneration from public funds. And then therein is the question of whether, because of that, can this qualify to be a popular or people-driven initiative? That will be answered, I think, by Counsel for the AG. The second clarification on my part is on the public participation. So far, since the Constitution 2010, we have been guided by weighing whether there was public participation on a case-by-case basis. The matter that is before us, the matters of Chapter 16 of the Constitution, looking at the complexity, our history, I would like some information on how public participation can be undertaken in this regard. Would there be necessary for there to be put a legal framework or some rules of procedure to that effect? That is what I would like to ask also from Counsel from INBC who submitted on public participation. We'll give 3 minutes to each to respond. Each of the parties who have been asked to respond, please take about 3 minutes.
May it please the court, Kirago Kimani for the 20th respondent. I'll try and deal with the questions from the two judges fairly quickly. But I think I'd like to give the context first. It must be borne in mind that the 20th respondent was not heard before the High Court. And the basis of the Court of Appeal decision was that once the Attorney General was disqualified, so to speak, from representing him, the court should have ensured, the High Court should have ensured he was served. Let's look at the questions now. And the reason I'm giving the context is that I stick to my lane. I have not looked at what the evidence was there on anything other than surveys. But I think it's fair to say that there's no admission that the 20th respondent initiated this process. And it's important that the court does hear something about what initiation means, because I think there's been a mix-up of the terminology. If it didn't initiate it, then there was nothing to pass on. There was no button to pass on. That's the long and short of it. But it's important that what the process entails is explained, and I think the persons best suited to do that are the 18th and the 21st respondents who say they are, or they were the promoters, so to speak. So I still have time, and I ask for them to nominate whoever will speak to this, because I think the court is entitled to an answer.
My ladies, my lords, I will answer that question, although I'll ask for some time later to make a few comments on the other issues that have been raised. The involvement of the President in this matter, I was trying to look through the Gazette notices. Unfortunately, I did not get it, but they're on record that there were two Gazette notices. One Gazette notice that set up what was the BBI task force, and a second Gazette notice that set up what was the BBI steering committee. And the words that are used in those Gazette notices asked both the task force and the steering committee to look into administrative, policy, statutory, and constitutional measures that may be taken in order to secure national unity. So first and foremost, it was not a direction towards recommending purely constitutional changes, but it was an invitation to consider whether there were constitutional changes that would be necessary if one was pursuing a measure towards uniting the country. And it is from both reports then that particular recommendations were made to say that, yes, there are constitutional amendments that we can make that would help in securing national unity. And the matter ended there after the President received both reports. It is the BBI National Secretariat that has described itself as an alliance of political actors that then took up and decided to pursue those constitutional amendments by way of a popular initiative. And therefore, the real promoters of the popular initiative then are the people who styled themselves as the BBI National Secretariat, who are the 21st respondent in this matter. Thank you.
If I could go back to Justice Lenaola's question, whether there's precedent in other jurisdictions. First, the starting point is that I could not, for the life of me, find anything that qualifies the President's right to do this for the reasons we gave earlier. But so therefore, I did not go out to look for this. But the Attorney General's submissions have actually given us examples, not of President, but political parties, political groupings. So when you do take time off to consider the submissions, the Attorney General has dealt with this at paragraphs 57 to 59 of their submissions. That's the first petitioner, and they've given the clearest example, which is Switzerland and what has happened, and it's nothing unusual.
Yes, my Lord, still on that issue that my learned friend, Mr. Kiragu, has just submitted on, just looking at an example of a popular initiative that has originated from a head of state, not a president, but a head of state. There's example of, it's a difficult word, Liechtenstein, I think is the word. The Article 64 of the Constitution provides for popular initiative, and in a referendum that was held on 14th of March 2003, actually initiated by the Prince of that country, the referendum was initiated and has voters to approve.
Mr. Karori, which country?
Let me spell it.
Yes.
It's a difficult word to pronounce. Liechtenstein. Yeah, that country. My Lord. Yeah, there was a referendum that was held on 14th of March 2003. It was initiated by the Prince of that country. It had asked voters to approve an extension of the power of the Prince to, among other things, nominate judges and veto legislation, and the referendum was passed. My Lord, while I'm on my feet, I think I should just answer the question asked by my Lord Justice Wanjala on whether when the popular initiative kicks in. It is correct, my Lord, that I did say that the popular initiative, the provisions of Article 257 are only engaged once the 1 million signatures have been collected. And the reason for that is obvious, that people will come up with all manner of ideas. They can try to popularize that idea, but if it does not, if 1 million registered voters don't sign up, don't support it and sign up, then the provisions of Article 257 are not initiated. In other words, my Lord, put it plainly, because I know my Lord has been a lecturer, so let me put this as plainly as I can. If you do not get the 1 million signature, you have not popularized your idea. It is not popular. It only becomes popular when you have collected the signatures of 1 million registered voters. I hope, my Lord, I've answered the question. Thank you very much.
You raised a very important question on why we say the Constitution has a basic structure, but the basic structure doctrine does not apply. My humble submission, sir, is that every Constitution has a basic structure which form the foundational parts of that Constitution, and where that basic structure is not specified in the Constitution, then it is the role of court in a judicial review to find out where it is. Within the context of our Constitution, historically in the making of Constitution, this is a matter which was addressed by the CKRC Commission, and at paragraph 746, it was recommended that a number of key constitutional issues should be entrenched in the Constitution, and they could be amended only by a referendum. So it did two things. One, it identified those key foundational parts of the Constitution and included them as thematic matters under Article 255(1), and further prescribed how those provisions can be amended. Now, there was the question which was raised by my Lord Justice Ndungu on whether what is the basis of the 4 sequential steps which were included in a decision by the High Court and the Court of Appeal. The 4 sequential steps were
My Leader is the election campaign portal featuring aspirants' profiles, their agenda, parties, non-governmental organizations, service providers, among others. Find the Kenyan aspirants. We promote women aspirants. Wamama Oye! My Leader is the election campaign portal featuring aspirants' profiles, their agenda, parties, non-governmental organizations, service providers, among others. Find the Kenyan aspirants. We promote women aspirants. Wamama Oye! Get to know aspirants' profiles, agendas, and manifesto. Connect and go live with video, calls, and live chats. Find timely election and campaign news and updates. Partner with us in the 47 counties for a better Kenya. Our campaign services include web design, bulk SMS, short code, ringback tones, design and printing of campaign posters, t-shirts, lassos, banners, among others. We have developed a parallel vote tallying system to help you safeguard your votes through real-time SMS. Get listed today and reach more voters. You have no internet access? Do not panic. Our mobile app has an offline access. You can also send Siasa to 22204. Contact us through our website www.myleader.co.ke. My Leader. My Leader is the election campaign portal featuring aspirants' profiles, their agenda, parties, non-governmental organizations, service providers, among others. Find the Kenyan aspirants. We promote women aspirants. Wamama Oye! Get to know aspirants' profiles, agendas, and manifesto. Connect and go live with video, calls, and live chats. Find timely election and campaign news and updates. Partner with us in the 47 counties for a better Kenya. Our campaign services include web design, bulk SMS, short code, ringback tones, design and printing of campaign posters, t-shirts, lassos, banners, among others. We have developed a parallel vote tallying system to help you safeguard your votes through real-time SMS. Get listed today and reach more voters. You have no internet access? Do not panic. Our mobile app has an offline access. You can also send Siasa to 22204. Contact us through our website www.myleader.co.ke. My Leader. My Leader is the election campaign portal featuring aspirants' profiles, their agenda, parties, non-governmental organizations, service providers, among others. Find the Kenyan aspirants. We promote women aspirants. Wamama Oye! Get to
on the question put to us relating, I think it is my Lord Justice Lenaola, relating to the ripeness of the referendum question. Our answer is a simple one.
My Leader is the election campaign portal featuring aspirants' profiles, their agenda, parties, non-governmental organizations, service providers, among others. Find the Kenyan aspirants.
And we are in the very happy circumstances of relying wholly on what Tuyot J.A. summarized it very succinctly at paragraph 251 of his judgment. And he says, these provisions, and more specifically subsection 2, places the responsibility of framing the referendum question to be determined on IEBC. In this instance, IEBC had not received the request to hold the referendum, and occasion had not arisen for it to discharge its responsibility of framing the question. Further, it had not been suggested that IEBC had already determined the manner or the formula in which it would frame the question or questions in respect of the referendum touching on the impugned bill. It cannot therefore be fair, and he proceeds. It was always our argument in the Superior Court that the High Court had acted totally without jurisdiction because it acted as the Supreme Court providing an advisory opinion. The High Court has no jurisdiction to provide an advisory opinion. And that question was not right, it was moot, and it was not open to the court. Finally, on the second question of my Lord Judge Ouko has asked, what is our view about the proposed change in the mandate of IEBC in the creation of these constituencies? And our position is very straightforward. Our powers are not what some of my colleagues are calling basic structure. I'm calling entrenched provisions. The powers of IEBC, its mandate is not entrenched. Its mandate can vary, can be amended, can be modified, can be by Parliament in its wisdom, by the referendum process, as whatever. So that we did not feel that it was necessary for us. If you give me
Yes, finish.
2 more minutes,
Yes.
because I wanted to offer purely gratuitously an opinion on the basic structure. So we did not feel like, if I may say this, my lady, this court has a jurisdiction that is very, very clear to hear and determine presidential cases. This court has another jurisdiction to hear and determine matters of great public importance. Supposing, just supposing, a bill was created seeking to take away the second part of your jurisdiction. I think that you may express yourself in the process of public participation, but you cannot, in my humble opinion, take the view that it is unconstitutional. And that is the position we took. Let me say something about basic structure, because I think there is a little confusion there. And I think from where we sit, basic structure means that part of the Constitution that cannot be amended because it is specially protected. Normally, it is specially protected from Parliament. The Basic Structure Doctrine Act operates in parliamentary system, if at all. And India was a good example, because you are stopping a transient parliamentary majority from fundamentally altering the basic law. In Kenya, what my colleagues have been saying, and what I support, is this. The drafters of the Constitution identified what was so precious that Parliament should not be left to mess around with it on its own. They then protected that. And that is why they are saying there is a basic structure in the Constitution. Thank you.
My lady, the Chief Justice. My Lady, the Chief Justice, you raised a concern about the question of public participation. So first, I would want to associate myself with the submissions by learned Senior Counsel, Mr. George Oraro, but to add just from the perspective of IBC that there is a decision, a locus classicus from this court in the decision of BAT versus the CS Health, which then sets out the principles upon which public participation is supposed to be conducted. It is our submission, my lady, that that particular decision fits very well on all fours with the provisions of Article 257. And so that the question of public participation under Article 257 can be achieved in an incremental basis, so that 257.1 on the question of the promoters, the courts agree that there is a limited public participation for the promoters to know what the bill is about. Then at sabbatical, that is Article 257.6, when the bill is sent to the county assemblies, again, the courts agree that it is not for purposes of changing the content of the bill. It is for the county assembly to then get an opportunity to consider the bill. So again, at that point in time, there's public participation. 256.7, again, at the National Assembly, there's an opportunity for public participation at that national level. And then finally, there's an opportunity for public participation in the referendum. And in the referendum, my lady, it is our submission that the IBC will have a role under Article 88.4G of the Constitution, which speaks to voter education. In other words, explaining to the voters how the process is supposed to be conducted. So it's a continuum. I'm most obliged, my lady.
My ladies, my lords, I'd asked permission to make two comments after the intervention I'd made. One is on the issue of the basic structure. And I want to refer back to my submissions yesterday when I talked about the romanticism that accompanies the words basic structure. And I say the words basic structure are not supposed to reflect something you go looking for in a constitution. It would be in the words we use when we talk about the spirit of a constitution, when we talk about the grundnorm of a constitution. You really cannot take any particular text of a constitution and start saying that you're looking for its grundnorm and say that it will be found in this article or in this section. Neither can you very specifically start looking for the spirit of the constitution. I think the position we are is that the words basic structure, much as they are used to reflect a theory in constitutions, in constitution making, they have unfortunately been imported to almost be a legal tool that can be used even in litigation. And I am saying that when you think about the words basic structure, you must also think about whether you can give similar significance to the word grundnorm and go looking for it, and whether you can give similar significance to the issue of the spirit of the constitution, which is always talked about, but I have never seen any court specifically go looking for a spirit of the constitution in any particular articles. On the issue of the referendum questions, my opinion is that there is always a mix-up when we talk about referendum as it is in the Elections Act and referendum as it is in Article 16. And there is a lot of mix-up between the referendum as you discussed the two. For instance, the phrase about framing the question is a very specific phrase that relates to a referendum that is conducted under the Elections Act. And it talks about an issue arising. The issue is taken to Parliament, which approves that the issue should be taken for referendum, and it talks then about IEBC framing the question that will represent that referendum, and for IEBC determining whether the issue to be resolved by referendum will be resolved in one question or in two questions. But if you go to Chapter 16, when it comes to amendment, there is no issue of raising questions when it comes to Chapter 16. And Chapter 16 talks of taking the bill to a referendum. So there are no questions. And if there would be a question, it would be a vote on whether you accept the bill or not. That is one perspective. But the second perspective would be that you cannot have single items taken to the people, because a lot of issues that have to go into constitutions are negotiated. In fact, very many, and I'll give the example, if imagining that the current constitution had been taken as different questions for adoption, one can immediately begin to imagine how many things would never have passed. Is it possible that with all the noise that there was, that a Christian majority would have gone and voted in for the protection of the Catholic courts had they been separate questions? So the idea of not allowing separate questions is because then constitution making becomes, you remove the negotiation from constitution making and make it a question of majority vote. While sometimes you need to tell the majority that they will not get what they want unless they accept what a minority wants. So even in public policy, they have to be separate questions. And lastly, on the four sequential steps, my opinion of this is that this was pure legislation from the judiciary. There is no reason, and I said yesterday that the assumption that having a constituent assembly is the best practice in constitution making assumes that it's a universal practice. We have not yet accepted that making constitution through constituent assemblies is actually the best practice in the world. So for it to be recommended to Kenya, was it because it's a best practice internationally, or because that is what the judge thought is what the way should go? Thank you.
Your Lordships, so that I defend my position, first of all, I associate myself fully with all my seniors who have submitted on that line. But in regards to the issues that were raised, and specifically I'm one of the people whose names was mentioned, I would like to draw the court's attention to, there is an authority provided by Mr. Orara Moke in his submissions as paragraph 8, Supreme Court of India in the Reserve Bank of India versus PLS General Finance and Investments Company Limited, 1987. It says interpretation of the Constitution must depend on the text and the context. Now, you asked a very important question, why we think Casavananda is not applicable in the current situation, and I'm going to point out that it does not match either the text and neither does it match the context. If you look at the Constitution of Kenya, and it is unique and interesting that Senior Counsel Githu Muigai has submitted on the parliamentary system of application of the basic structure in relation to the Indian Constitution. And yesterday I provided to this court that is provided for under Article 368 of the Indian Constitution, which is the exact kind of parliamentary system that is predicted under Article 256 of the Kenyan Constitution. The Indian Constitution lacks in substance Article 255(1). The Indian Constitution does not have Article 255(1). And therefore, on that ground alone, there is a difference in context. If you come to the both context, there's a difference in text. Now, if we come to context, which again marry with text, we find that the Kenyan Constitution, on a very distinctively different path with the Indian Constitution, introduces the referendum. The referendum is not a provision of the Indian Constitution in any way. Looking and considering that path of the referendum, it means the power has been thrown back to the sovereign, to the people. And therefore, the issue of contradiction is not that we were saying that there is a basic structure and again say it does not apply. We were saying the basic structure is that provided by 255(1), but there is a submission from our opponents which have gone on from the High Court to the Court of Appeal and soon coming before you, that there is another supra-constitutional, extra-constitutional powers that provide another element and elevates another thing called the basic structure that is different. So we are saying that theoretical kind of basic structure does not exist because our Constitution provides for that basic structure under 255(1), which gives the power to the people. And therefore, we submit that there is no contradiction at all. We have a basic structure. And that constitution has also confirmed the context, and the context was well expounded in Kivuitu, when Kivuitu, the case that we mentioned yesterday, said very well, and I repeat, we agree with the sentiment expressed by Ringera J, that an amendment that upsets the structure of the constitution could not be effected by parliament without involving the people. So the court realized that there's an amendment that can upset the structure of the constitution, but as long as the people are involved, you can still amend that. Just one line so that I sit down and rest in terms of the multiple questions or one question. It was my submission yesterday that is, as far as I'm concerned, an immature matter before the court, because the IBC had not reached there. Therefore, if any court, best the High Court or the Court of Appeal, pronouncing itself on matters which were not yet ripe, maybe the courts will be sitting in another jurisdiction offering advisory opinion, rather than sitting on real matters of facts that should be determined. And even if the court again makes a pronunciation to confirm that, then the court will be, as currently constituted, is not a court that offers advisory opinions. I rest with that, Your Lordship.
Thank you. I think we'll hear from Dr. Oganda. We are giving 3 minutes. I think something went wrong with our timer, so that we don't rehash what was said in the submissions, just to focus on the answer. Dr. Oboso. Sorry, Eboso, sorry.
I'll quickly go through. The 4 sequential steps are not expressed in the Constitution, but they are implied. My submissions to the Supreme Court, I have demonstrated how the popular initiative has public participation all through the process, right from starting from the collection of signatures. And in the collection of signatures, the person convincing 1 million people definitely is taking the views of these 1 million people, and they are saying, we support this. Constituent assemblies do not have to be named constituent assemblies. Constituent assemblies are any body that is elected for the purposes of amending or reconstituting a constitution. The county assemblies, therefore, being elected, and even the National Assembly being elected, conform into a constituent assembly when they are considering an amendment to the Constitution. And then, of course, we have a referendum. So the 4 steps, they may not be sequential, and they need not be sequential, but the 4 steps are implied within the Constitution. Can the President initiate legislation? Yes, he can propose legislation to Parliament, and there is a framework for that. I captured that in my submissions at the High Court, that I think the standing orders permit a cabinet proposal to be tabled in Parliament. Secondly, the President issues State of the Nation address every year and an address to Parliament. Through that, he'll be making proposals to Parliament on what to do, but the President cannot himself legislate. Same way, the proposal by the task forces under the President could have been made and taken up by anyone to pursue a popular initiative. The problem in this came from the fact that the national executive put resources now to support it through now the collection of signatures in terms of using state resources to collect signatures. And that's where the problem came in, that once the President proposes it, then it is up to anyone to take it up and use their own resources, do whatever they'll do as individuals to pursue it. Can the promoters be, are the promoters restricted to seek help from politicians? They may seek help from any other person that is not the state. A constitution defines the relationship between the state and the people. Anybody who is not the state would be considered the people. Civil society and so on and so forth, they could come together and move. Even political parties, to the extent that they are not part of the state, can do that. The problem comes in when state resources now are put into this, or it becomes a state project to amend the constitution, because the state is what is meant to be limited. The nature of sovereignty, really what you're asking is who is the people? Because the sovereignty is really, we've said the sovereignty belongs to the people, so it's the people who are sovereign. But what is the nature of sovereignty? Now, sovereignty is both under and extra constitutional, in the sense that it can be under, and when it is under the constitution, I think my time is up, but yesterday I had 1 minute left. when I presented. I'd like that 1 minute now. I'm on the last question, though. The nature of sovereignty is such that above the Constitution, you cannot define sovereignty. You can only know that it exists. It's like the concept of God. You can only understand the God who's described in the Bible or in the books that we are given. But you can't know God beyond the books that you're given. So sovereignty in this state, we can understand who the people are under the Constitution because they are defined. But above the Constitution, we can only know that they are there. And they can manifest in a coup. When a coup happens and the people accept the new government, that's the sovereignty that has accepted that government. And so above the Constitution, you can only recognize or give legitimacy through the theories of recognition of law, not through the Constitution. And that's why I was saying, under the Constitution, the only legitimacy we can give is that which has been done in accordance with the Constitution. So the nature of sovereignty, I talked about it in my submissions at the High Court extensively, and I think some of the authorities I gave on the nature of sovereignty would assist in that. Thank you.
To Justice Lenaola, issue of multiple or singular questions in a bill, the rightness issue or premature and all that. What the Constitution of Kenya Amendment Bill 2020 was a bill which had several issues contained in it. And because a bill was already presented and we're dealing with the bill, that issue was not premature as such because we're dealing with the bill. And therefore, because we're dealing with the bill, we have to consider what should be contained in that bill, and it is a consistent message in Chapter 16 that only a single issue can be contained in that bill, as it was a bill that was presented to the people of Kenya. I'll now move to Lady Justice Ndung'u. Whether or not we should have legislation in Parliament to legislate whether we have a single question in a bill. At this stage, because we were presented with a bill prior to any legislative arrangements on the matter having been put in place, I will suggest it is not necessary. It is a question of this court interpreting Chapter 16 in relation to the Constitution of Kenya Amendment Bill 2020. Chapter 16 is consistent with only a single question in a bill. We had at least 74 different questions in the Constitution of Kenya Amendment Bill. So therefore, this court should nullify that particular bill on that basis. It wasn't constitutional. It didn't comply in terms of consistency with the Constitution. A third question was whether if the functions of the president include, for example, pursuing national unity, and in his opinion, he felt that he needed to have the Constitution changed to aid him in the pursuit of national unity, would that be permissible? I will suggest that if you look at the Constitution as a whole, in a holistic manner as opposed to in a piecemeal manner, including Article 259, Article 159, including the spirit and purpose of the Constitution, I think we have in our Constitution all that we need. When we give the President his functions concerning the things he's supposed to do, and we give him this is the Constitution, these are the rules by which he should play at, that is more than sufficient. I think in this particular case, since that was the case before this court, I think the principals, meaning Uhuru Kenyatta and Raila Odinga, had additional purposes of pursuing. They wanted to change the executive. They wanted more space for more politicians. In their opinion, that would kind of quieten the tensions that you normally have every 5 years. That was the opinion. But then, if all of us are willing to accept the electoral will of the people through an election, we accept it, we respect everybody's opinion, everybody's entitled to an opinion, that's already in our Bill of Rights, we don't need to have those kind of mechanisms. In other words, what I'm saying, what we have in our Katiba is sufficient already to do the job of a president. We don't need to change the Katiba for the president to be able to do additional things he wants to do. I mean, if he's doing his job, it's sufficient. If he wants to do additional things, that is different. He puts a proposal and we consider it as appropriate. Thank you.
Thank you very much. We'll now move to the next segment of the hearing, and we'll start with the third appearance. Just hold on. I think there is a question that was not answered, and Judge wants to follow it up. Just a second.
Thank you again. My lady. Perhaps this may be raised, may be answered by Council Morara, perhaps when it comes next. But I had asked those who are together with the appellants whether the majority decision in the referendum question was indeed the majority decision. I didn't get any answer. Perhaps we can hear from Mr. Morara, but I had intended it to go to those representing the appellants.
If you're not ready, you can do it in your response. The appellants can do it in their response. We can have this time now given to the third appellant. You have 1 hour, although I realize that you were donated some time, and I think the timekeepers know the time which was donated to you. If you need it, it will be given to you.
My Lady the Chief Justice, the President of the Supreme Court, Honorable Justices of the Supreme Court, it's almost afternoon, good afternoon. My name is Topua Lesinko, and I appear together with Mr. Morara Omoke and Ms. Margaret Kamau and Mr. Justice Nyaga on behalf of the third appellant. Before my lords and my ladies, I introduce our submission, and with the leave of Mr. Omoke, we did note that deliberate effort by the first appellant and the IBC to ignore the question by the Honorable Justice Ouko, and we note that the third appellant did indeed submit a letter requesting for review of the holding of the Court of Appeal on that particular issue of separate and multiple question. And I think your position is really qualified by the finding of Justice Gatembu Kairu in paragraph 197, Roman 4, where he just said that I do support the separate and multiple questions, but subject to the proposed amendment. So in our opinion, we thought that he was together with the three other judges, including Justice Nambuye, Justice Patrick Kiage, and the President of the Court of Appeal, and therefore it should actually have garnered the majority. But that notwithstanding, he will deal conclusively on that issue. In the course of our submission, we shall be relying on our submissions file on the 6th December and dated 24th November 2021, and also volume 21 of our record of appeal dated 15th September 2021. I shall be submitting on the first and second issue, namely the applicability of the basic structure, doctrine, and popular initiative. And just to flag this, I shall answer all these questions in the affirmative that indeed it applies. Also, towards the end of my presentation, I will attempt to provide a response to the various questions that have been asked. My colleague, Mr. Omoke, will be covering the following 4 issues: the constitutionality of the second schedule of the amendment bill, the place of public participation under Article 10, the issue of quorum of the Independent and Electoral Boundaries Commission, and whether Article 257.10 envisages a separate and distinct referendum question, though we filed this appeal reluctantly, noting that it was indeed an error by the Honorable Judges of the Court of Appeal. My ladies and my lords, today we appear before you to defend the Constitution of Kenya against a coup d'etat by the trustees, the political elites, who were bestowed with the solemn duty of protecting, preserving, and upholding the Constitution. At the end of every election year, the president is sworn into office, and I personally have never been present physically in those events, but if my mind serves me right, one of the things that is normally given is the People's Charter, the Constitution, or what Professor Guy calls an imposition by the people on the political elite. At the end of the 5 years, the president is required to deliver that baby, the constitution, back to the people, alive and kicking, not a dismembered or disfigured constitution that lacks identity and its structure. Indeed, if I had the liberty to characterize the current proceedings before you, my lords and my ladies, I think I will name it the people versus the constituted powers. And we are going back to, I think, the eras that scholars like Professor Nabweze in 1984 in Presidentialism in Commonwealth Africa, Okoth Ogendo in his article Constitutional Without Constitutionalism, published I think in 1993. It was a book chapter widely available, where they were decrying the overarching power of the imperial presidency. So that is exactly where we find ourselves today. And I will just, before I delve into my submission, correct submission by Mr. George Gilbert, trying to distinguish the issue of the basic structure doctrine. Mr. George Gilbert actually attempted to distinguish the basic structure, and he did agree that the basic structure is applicable pursuant to Article 255 and the basic structure doctrine. And I am comfortable, either my lords, to use the basic structure and not the word doctrine. And I note actually the definition of the word doctrine as defined in the Oxford Learner's Dictionary is just a belief, a set of belief. You are not actually sanctioned or to use it mandatorily. You can actually ignore. But I'll argue towards the end of my submission that because of the issues of constitutionalism and what Professor Rosnai says, that we are in an era where executive powers are constrained, that even in the express requirements that amendment of the Constitution is limited, the same can be implied. It's my submission that our history, our text, and the context, and I know that your lordship, under Section 3 of the Supreme Court Act, and based on the concurring decision of Mutunga in advisory opinion number 2 on the Senate, he says that this honorable court has an elastic power to not only look at the context, but the history. And our history today is the amendments of 1966, for example, that did away with the Majimbo system, ultimately returned under Article 255 on devolution, and this is actually one of the ring-fenced provision. It's one, another thing is the issue of, for example, fair trials, which were germane in the President Moi and President Kenyatta, founding President Jomo Kenyatta era. So it's that history of amendment that the people wanted to undo. And at the beginning of the agitations for reform, especially in 1992, I know that there was a Kanu Review Committee. And later, jumping to 1997, during the IPPG, the people actually coerced to say that we are not accepting the IPPG because we must be part. And I think ultimately it led to the People's Commission and the Mfungamano Initiative. And so the people wanted not only to have control of the content in the Constitution, they wanted also to have control over the process. And the process in this regard is popular initiative provided under Article 255 and 257. Therefore, the intention was very, very clear that they must not just be part of the menu, but they want to be present in that table where the Constitution is being promulgated or made, or in this case, because I do concede that the power of amendment on consequential issues was given to the constituted powers, but not on the substantive issues under Article 255. So, coming back to Mr. Gilbert, and maybe Senior Counsel Paul Mwangi, Attorney General, and George Gilbert, they discussed the origin of the basic structure to be an importation from Professor Conrad in Germany, to India, and now mysteriously finds itself in the corridors of justice in Nairobi. And which actually I think Professor Rosnai, just after the High Court judgment was released in May 19, 2013, characterized it as a, just a minute. Interestingly, he used a very interesting title. He said that the basic structure doctrine arrives in Kenya, the winds of change for constitutionalism in Africa. And that was barely 6 days after the High Court gave that judgment. And in our submission, we've argued that it's not a new concept. Justice Ringera in the Njoya vs. Republic case in 2004 alluded to this in detail and discussed the constituent power of the people. And I think the people also, under the commission, review commission, I think 2005, if you look at page 76 of that report, of the final report of the CKRC, there's a very interesting commentary that is provided of what will ultimately come to mutate to be Article 255. So there's a very important paragraph. The Attorney General has cited it. It's paragraph 7.26 of that report. And you could actually see that the whole issues, including supremacy of the Constitution, independence of, including the judiciary, issues relating to devolution, have been ring-fenced. And so for me, I think, and I do agree with the findings of the High Court, paragraph 471, providing that the foundational features form part of our basic structure. And the people have actually clearly outlined that under the CKRC report, that the basic structure doctrine do not apply, which it's our submission that it applies. But in the case that this court goes along that tangent of argument, it's our submission and as considered by Mr. George Gilbert, that it has a basic structure. So take away the doctrine, they've agreed that it has a basic structure. We have, in relation to the argument that it has a basic structure, based on the aspiration, vision, a spirit, and the textual wording of Article 1, that the people are sovereign and they delegate some of the powers to the judiciary, executive, and parliament in trust, the people still retain the residual power on the most fundamental things under the Constitution. And that, for me, I think it's Article 255 and Article 10, which I think has attained what in international law is termed as jus cogent. But equally, I'll add the Bill of Rights to that, which I think is very important. So therefore, that even if you take the basic structure doctrine, the argument still stands, and the first appellant and those in support agree that it indeed has. And I will be highlighting that even in the High Court judgment, the Attorney General did in fact agree at some point that the basic structure doctrine applies. It's only that goals have been shifted, including even in the question of who the promoters were, which I'll be dealing later. But that still leaves their case exposed. If your lordships and ladyships agree to the finding that it has a basic structure, which is a reflection of the aspiration and vision of the people, then the argument will be that Article 255, 256, 257 exist to limit amendment of the Constitution by constituted powers, not by the ordinary mwananchi. In that regard, I fault the first appellant submission and Mr. George Gilbert's submission again, to the effect that, and the wording they used was that the Court of Appeal, the Superior Court, misconstrued in finding that the Constitution limits the power of amendment. I don't think it limits. What they will have done, they will have continued and says it limits the amendment of the Constitution by the constitutional powers, and these include the President and any other state officer. That means that if this court was to arrive to a different conclusion that it was not the President who commenced the popular initiative, and which I don't think they have the leeway to do that, because the question presented to this court was whether the President can initiate the popular initiative and not who the promoter of the popular initiative was. That was done and dusted at the Court of Appeal and the High Court. And Mr. Wele for the BBI Secretariat yesterday tried to introduce that line of argument. I think it flies on the face of the rules of this court, because it was not part of what was submitted before you. And I think the most relevant things for them to have done is appeal on that factual issue. They never done. So the trajectory and line of argument that this court must adopt is whether the President can commence a popular initiative. There's no room for importing any other person to the equation. It's completely locked. And I do say that the High Court and the Court of Appeal did convince themselves beyond reasonable doubt that the Constitution Amendment Bill 2020 had all manner of footprints of the President in it, including how the process was initiated after the handshake, and actually to comment that Dennis Waweru and Junet Mohammed only jumped to the ship later on, and coming to say now that the BBI Secretariat is kind of an organization trading under this name. And I do note that that was a ploy to be able to give it a connection to an entity defined under Article 138 of the Switzerland Constitution that allow political alliances to initiate a popular initiative. But that, in our context, it flies on the face of it. Article 257 is very clear on how the process begins, and there are late efforts to lump two state officer and a member of parliament, because I do understand that at that time, Mr. Waweru was actually serving as a chair of Ken Invest. And Mr. Junet Mohammed, on the other hand, is a member of parliament, an active member of parliament, who the Constitution entitled to recourse to Article 256 to move any consequential legislation. And my lords, you note that the first appellant actually comes to this court not with clean hands. The Constitution is barely 11 years old. Article 27.8 that gives the state the mandate to operationalize things like the two-third gender rule, the judiciary fund, the equalization fund is still pending. And I think, I do agree that the life of any constitution, as alluded by professors like Richard Albert, is 19 years. It's the right of every ordinary citizen to move that amendment. And as the High Court and the Court of Appeal has held, Wanjiku has a right. The Constitution doesn't limit. It only limits constituted powers. And I think that must be understood. And with that clarity, I don't think that the first appellant and those in support will have any problem in now saying, for me to reluctantly say that the basic structure doctrine, in the case of Kenya, because the High Court, for me, introduced a new line of thinking on the basic structure issue. Because if you look at the basic structure in India, it completely locks the room for amendment by parliament. and actually introduces issues of unamendable and eternity clauses. At around, I think, paragraph 472 or thereabout of the High Court judgment, the 5 judges are very emphatic and clear that all 18 chapters of the constitutions are amendable, and therefore, to the extent that they follow the basic structure doctrine and its applicability in Kenya for locking out amendments, I think leaves them to have misconstrued that decision. Because our understanding, and that of the third appellant, is that the finding was all 18 chapters and the 6 schedules of the constitutions can be amended. And on the first sequence process in relation to that, I think it's actually, I can term it as expanded public participation. I don't think there is anything wrong with the Constituent Assembly. It's just a fancy name. When you walk out of this gate, maybe some 4 years ago, you'll find the Bunge la Wananchi. That could be a perfect description of what a Constituent Assembly, and those gentlemen out here are very vibrant in discussing day-to-day matters that are germane to our legislation and governance system. And so I don't, it's not some rocket science thing, like a collection of views. Your lordships and ladyship have articulated that while discussing public participation in the British American tobacco case. And to Justice George Odunga in the Robert Gakuru case have also extensively expounded what public participation is. And so for me, I don't, the 4 sequence process do not shock me in any way. It's some form of expanded public participation. And as I had intimated, Article 10, which provides those principles and values, is now very important to the operation of our system and governance. Maybe just to pick a comment by Senior Counsel Kamau Karori on the issue of Liechtenstein and the Prince extending its term limits. To an extent, I see Liechtenstein not to be a good example because him alluding to a prince leads us to some monarchical side of system of governance. To that extent, I don't think it will provide a good comparison for comparative purposes because the Constitution provides that Kenya is a republic. And if, for example, I was to extrapolate the issue by the Prince of Liechtenstein on the term limits, I'm not sure whether anyone introducing extension of term limits in our current constitution, though they are entitled, the ordinary mwananchi is entitled to actually move such an amendment. But I don't think it is a perfect example just because of the system of governance. And we have been termed as one of the most progressive constitutional democracies now in the world, ranking with the likes of South Africa. And therefore, I think that example will not suffice. Just to touch something relating to the mandate of this court, while arriving at the does provide a good analysis of general theory of interpretation by the Supreme Court. And if I just quote, Article 20, sub-Article 4, Article 259(1), Article 259, and Article 259 lays down the rule of interpretation as follows: that the Constitution shall be interpreted in a manner that promotes its purpose, values, and principle, advances the rule, allowing the court to make forays into the country history and cultures, to dig out the people's expression reflected in the text and spirit of the Constitution. So text and spirit of the Constitution. And Chief Justice William Mutunga further qualifies that these provisions grant the Supreme Court a near limitless and substantially elastic interpretive power. It allows the court to explore interpretive space in the country history and memory, and the history and memory that appeal to your lordships and ladyships is our history. After we got independence, till such a time, I think, around 1997, because 1997, the Kanu regime had already given room for the people to come to the negotiating table. So I think that history, and I will refer you, moved by the president to take away the powers of parliament to nominate, I think, around 12 members at that time. And that mandate by parliament was actually revoked, I think, in a single afternoon. Same to the 1982 scenario of introducing a one-party rule, or even 1988 where security of judges, 10 of judges was taken away. I think those are some of the fresh memories that really should tinker in the mind of anyone reading and interpreting this Constitution. So Justice is that let's close our eyes on where we came from and focus the textual provision. And I didn't submit that the textual do not favor in any way the president commencing a popular initiative. It doesn't. And if you will allow me to read Article 255, reading it with Article 1 on delegated powers and the Constitution as a contract to the constituted powers. 255.3 says, sorry, I think I'll take it back. And that my finding is that the text of Article 255 is only a preserve of the people with Parliament. The people commence the initiative under 257 as a form of a general idea, and that they must be the promoters, not a state officer, and follow all the steps outlined under 257. And by extension, I will also refer your lordships and ladyships, the Supreme Court of India in Reserve Bank of India versus PLS General Finance and Investment Company Limited, the 1987 case, again reiterating the issue of interpretation of the Constitution in determining the applicability of the basic structure in Kenya. And also just to cite the finding by Justice Tuyot in page 88, the history on hyper-amendments of the Independence Constitution and consolidation of power within the executive in Kenya is very relevant in providing context onto the interpretation of Article 255, 256, and 257 of the 2010 Constitution. And it's our submission that it had been submitted before the High Court and the Court of Appeal that Chapter 16 had retained its version in most of the drafts, either the Bomas draft, the Wako draft, revised harmonized draft, that shows that the intention of the people was very, very clear. And it has also almost been produced as a copy-paste under Chapter 16. The framers of the 2010 Constitution, which subsequently have been adopted by the people in the preamble saying that we the people, had the overarching goal of undoing all those loopholes between period 1964 and 2010, when the Constitution was ultimately promulgated, that befallen the previous Constitution. And that actually takes me to the finding by Justice Lenaola, then the High Court judge, in the Commission of Implementation of the Constitution versus National Assembly, a 2013 case, saying that the judges have a duty whenever the identity and architecture of the Constitution is under threat. Today, that problem again is before you, and following the dictum by the Honorable Judge, this Honorable Court has the duty to protect the architecture and design of our Constitution. And that duty is given to you by the people of Kenya under Article 1. And I just want to laud this, the whole judicial system, that despite the challenges they face in obedience to the court orders, which orders shall never be given in vain, I think post-2010, the judiciary has been one of the most reliable and the beacon of hope for the people of Kenya. And let me just randomly mention the Security Laws Amendment case in the first term of the Jubilee government that seeks to sweep most fundamental rights under Chapter 4, under the carpet. And I think the bench, I don't remember if it was a 3-judge or 5-judge bench, then rallied in defense of the Constitution. And my clarion call is that you, Honorable judges or justices of the Supreme Court, must also protect the Constitution for posterity. And if I may refer you, your lordships and ladyships, to the wordings of the preamble, which is, I think, very unique, and also coming at the very, very beginning of the Constitution. In the preamble, the people says, "We, the people of Kenya, adopt and enact and give this Constitution to ourselves and to our future generations." We adopt, enact, and give the Constitution to ourselves and to our future generation. For me, the issue of future generation is very key. It's a very, very key word. That the intention of the people was that you can amend, not fundamentally, maybe issues of issues not ring-fenced under 255, but let's try and keep it for the future generation. The Constitution is 10 years old. If a child was 10 years old, I'm not sure if they're actually in a position to start actually eating things like getheri. This Constitution is still trying to develop its teeth. It's not even a teenager, strictly speaking. And I think the solemn duty of the president under that schedule will have been to preserve, uphold, and respect by operationalizing, among other things, the two third gender rules, the judiciary fund, the equalization fund, rather than spend a whopping 20 billion taxpayers' money for purpose of amending the Constitution. Or I wish if that money was actually allocated to the judiciary fund to give room to more small claims court or building infrastructure for either the judges or courtrooms. That would have been my ideal wish. And This court may get persuasion of the phrase "we the people" by seeing as in it's also provided under the U.S. Constitution and the Indian Constitution. And interestingly, as in I found that the U.S. Constitution, despite the fact that it has been, since its conception in 1787, 235 years ago, the people have only amended 27